I'll moderate informally from my position as the class commentator. Are we going to go
Ahdieh, then me.
Somin? Okay. That just makes thematic sense. So sure, I'll put it at the bottom.
Great. Well, thanks for having me here, to the Law Review editors and to Peggy and to everyone here. I'm very pleased to follow Judith in the presentation, as I have on a couple of prior occasions, because I can summarize my comments largely as ditto. I'll elaborate slightly, but that will largely capture much of what I want to say. In substantial part, my scholarship over the years has revolved around essentially the notion that Judith puts before us, that we should move away from what I describe as the traditional project of law as one of allocating jurisdiction, dividing jurisdiction, defining jurisdiction, as line drawing and defining boundaries, towards an embrace of jurisdictional overlap and perhaps even regulatory interdependence among independent or otherwise independent regulatory authorities. Rather than something to fix or something to address or something to correct, thus, I see jurisdictional overlap and complexity as something we should acknowledge and even integrate and embrace. So I've pursued this interest or this study under or by way of sort of attention to the benefits and in turn the nature and finally the implications of various patterns that I put under the heading of intersystemic governance. As I outline in the paper, I sort of start with sort of four potential benefits, four possible benefits that might arise from these patterns of so-called intersystemic governance. The first is that these patterns of jurisdictional overlap and regulatory dependence may allow a closer alignment of law and regulation with the subjects of regulation, by which I mean both the actual subjects, the individuals and entities that are subject to regulation and that are increasingly possess a cross-jurisdictional, multi-jurisdictional character, and also the issues subject to regulation which have similar cross-jurisdictional, multi-jurisdictional character. So that's the first potential benefit. The second potential benefit assumes that there's a certain degree of regulatory inertia that we face, and the question becomes whether these patterns of jurisdictional overlap may help us to overcome such inertia, may in essence facilitate patterns of regulatory innovation and, regulatory initiative that break with these patterns of inertia that might otherwise exist. The related phenomena that I already suggested is the idea that, that perhaps intersystemic governance may foster innovation, that in essence, it's sort of the extension of inertia. One is to break away from pre-existing patterns, and the other is to affirmatively encourage new ideas, experimentation, so on and so forth, in regulatory design, fostered by a certain pattern of regulatory competition that arises through such jurisdictional overlap. I've pointed to these kinds of patterns in federal and state securities regulation, suggesting that sort of we see some kind of a tit-for-tat pattern of regulation between federal and state authorities because of the extent of overlap. Finally, to the extent that, in terms of benefits, to the extent that, that some degree of alignment, some degree of harmonization has utility, some degree of regulatory harmonization has utility, patterns of jurisdictional overlap may offer a fairly incremental and non-invasive mechanism for its pursuit. So as opposed to, harmonization or standardization dictated from above, intersystemic governance may again create this tit-for-tat, back and forth pattern by which harmonization is achieved. Paul Berman points out in his paper that some of the utility of these patterns that he describes as pluralism may actually be the avoidance of harmonization, that we avoid unnecessary harmonization. Where harmonization has utility, though, where we like harmonization, where we want harmonization, intersystemic governance may be an effective means to achieve it. So those are four benefits, perhaps, of this pattern of intersystemic governance. Next, four characteristics or four facets, four features that I've identified of intersystemic governance. The four of them I'll list first. Jurisdictional overlap, of course, is one. Dynamics of coordination is a second, that we've already heard some about. Patterns of dependence among regulatory institutions, and a growing role for persuasion rather than more hierarchical mechanisms of regulatory control. So a word on each of these four. First, again, as Judith described in great detail, increasingly state and local authorities share jurisdiction with the federal government, with federal authorities in the regulation of particular individuals, particular institutions, and even particular conduct. Thus, in corporate and securities law, again, where I've written some on the issue, I pointed out the ways in which, during Elliot Spitzer's tenure as Attorney General of the state of New York, in essence, the SEC was forced into a pattern of engagement, coordination, so on and so forth, overlap with Eliot Spitzer. Conversely, if we think about the world after the adoption of the Sarbanes-Oxley Act, in essence, the states are being forced to accept overlapping jurisdiction over corporate law with Congress and the SEC. So the first then is jurisdictional overlap. Second, dynamics of coordination. Here the idea, again, suggested by Judith, is the emergence of various mechanisms of coordination. Judith's intergovernmental networks, including the National League of Cities, and various more formal ones and less formal ones, may be exemplary of these patterns of coordination, these networks of coordination. So that's a second, perhaps, institutional characteristic of intersystemic governance. A third, and perhaps more striking feature, is this pattern of dependence that I mentioned. Now, it may be easiest to capture this pattern of dependence by reference to the work to which I trace my own interest in these patterns, an article now some 30 years ago by Bob Cover and Alex Alenikoff entitled Dialectical Federalism, in which they in essence describe a pattern of interaction between state courts deciding criminal cases, state criminal courts, and lower federal courts adjudicating habeas claims, state habeas claims. And they suggest in essence that the Warren Court established by dint of its constitutional jurisprudence of criminal procedure a pattern of dependence between state criminal courts and federal habeas courts by which neither institution could establish its relevant policy objectives, its relevant goals as to constitutional criminal procedure without the coordination, the cooperation of the other entity. That's the pattern of dependence, in essence, that I'm interested in. Again, I've talked about it in other areas, but that's the essential idea of this third feature. Finally, the last feature, just to mention it, is some growing orientation, again, to dynamics of persuasion. The idea that, again, Judith has suggested in some of her work, that the quality of argument and analysis becomes increasingly important to regulatory efficacy. That because coercion is not the dominant paradigm, persuasion becomes dramatically more significant as a way to judge and evaluate and estimate, in some sense, the regulatory effects of a particular institution. All right, so those are four perhaps facets or characteristics of the pattern I described. Now, I want to spend the rest of my time thinking about the implications of these patterns of intersystemic governance, in particular about the implications of patterns of intersystemic governance, of horizontal federalism, of pluralism, as Paul will describe it, at the domestic level, the implications of these patterns at the domestic level for the international level. What are their implications there? The most basic point, of course, is that we might simply consider the replication of these domestic patterns transnationally. In essence, if we like the idea of domestic jurisdictional overlap, overlapping jurisdiction between local, state, and federal entities, perhaps we can replicate that in some ways transnationally. So in certain areas of international trade law, in a lot of areas of environmental regulation, in anti-terrorism efforts, anti-corruption efforts, anti-money laundering efforts, we already see sort of patterns of intersystemic governance operating. Right? That's really the pattern of regulation in many of these areas. I want to sort of focus today, though, on what I would describe as an even stronger possibility, or more forceful possibility of the implications of the domestic patterns for the international level. Basically, I want to suggest that intersystemic governance in domestic federalism, domestic intersystemic governance, may undermine our traditional notions, our traditional conceptions, in some sense, the conventional wisdom about the impact of international law, or the relationship of international law with domestic federalism and the domestic legal system. To think about this, I want to start with the question of what international law is doing in the face of a domestic regime of dual federalism, a domestic regime of categorical federalism, the pattern that in some sense, again, Judith is rejecting, and that I think, as I describe in the written paper, I think can increasingly be considered to be inapposite or no longer descriptive of what we see in terms of our domestic constitutional order. So what's the role of federalism in that context? Often, and perhaps increasingly, I want to suggest that international law can be understood to be serving a coordination function with both outward and inward directed dimensions. So again, serving a coordination function with both outward and inward directed dimensions, by which ultimately, sort of again, in the intersystemic governance world, international law empowers or gives voice to subnational actors rather than silencing them. So let me start with sort of the outward directed dimension. Here, Paul Stevens' earlier discussion of coordination games seems to me quite a posit and relevant. as Paul pointed out, the international law scholarship, in some sense tracking the legal literature generally, has tended to exhibit a strong orientation to prisoner's dilemma game dynamics in evaluating the motivations for regulatory intervention and trying to understand why we regulate and when we regulate. Far less attention has been given to coordination game patterns, by contrast. This is the proverbial, as Paul mentioned, question of which side of the road do we drive on? Do we drive on the right or the left? And even probably more paradigmatically, it's the meeting place game that Thomas Schelling described of the two of us being separated in New York City and trying to figure out where to find each other, where do we meet. Here, in this coordination game dynamic, there is no incentive to defect from a coordination equilibrium, even an inefficient equilibrium. The pattern is, in some sense, exactly the opposite of the prisoner's dilemma dynamic, where our worry is defection. Here in coordination games, we're not concerned with defection. There isn't an incentive to defect. As such, the question in the coordination game dynamic is not the incentives of the parties, but instead their expectations of one another. So what we are trying to shape by any regulatory intervention or the lack of regulatory intervention is the expectations of the parties of one another, not their incentives to behave in one way or another. So then what does that mean then for this outward oriented role, this outward directed role of international law in the face of a dual federalism or a categorical federalism regime? The outward dimension is fairly straightforward. Basically, it's what we think of international law doing. Across an array of areas, international law can offer an effective, if not necessarily the exclusive mechanism by which national authorities can coordinate with other national authorities to pursue relevant policy ends. That's the externally directed dynamic of coordination in international law. The inwardly directed dimension of coordination in international law, in some sense, or I would say often, functions in service of the latter, and functions in service of the externally directed coordination function. Thus, whoever the relevant domestic authority is with responsibility, with authority to regulate, to shape foreign affairs in our dual federalist regime, will in essence, in many cases, need to bring the incentives and the interest of various subnational entities in line with the relevant foreign affairs policy initiative, right? So externally directed coordination is national authorities coordinating with other national authorities. Internally directed coordination in international law is getting subnational entities, getting local and state entities in line with the program, getting them with the program. This need not always be the case, this second piece. In fact, inward-directed coordination may be an end unto itself. Inward-directed coordination may not be serving the externally directed pattern of goals of coordination. Instead, it may be, again, an end unto itself. This, in some sense, is arguably the story of Holland versus Missouri, right? So the idea in Holland versus Missouri is the end was already resolved. In other words, Congress had determined the desired policy initiative. And the only function of the international law intervention, what the international law was doing, was serving the predefined, in some sense, policy end. Regardless of whether the internally directed coordination function is in service of the externally directed goals or is an end unto itself, the conventional account of the relationship of international law and federalism, in some sense, arises from this internally directed coordination function of international law. Thus, the notion is that international law is in tension with federalism, that international law and federalism, international law and state and local interests are in conflict with one another. International law, again, functions to coerce, to limit, to constrain, to silence subnational voices. And again, I want to suggest that we in fact may get, just the opposite result as the domestic paradigm shifts from one of dual federalism, from one of categorical federalism, to one of pluralism, horizontal federalism, intersystemic governance. So how does that play out? First, as to the externally directed, what happens when we shift to the externally directed coordination function? Well, in one account, we get chaos, right? So Judith's analysis of the foreign affairs preemption idea, in essence, is premised on the notion that if you start letting state and local entities into the picture, you get chaos, right? There will be no coherent policy, no coherent foreign policy of the United States if state and local entities can intervene whenever they choose. Considered more carefully, though, it's not so clear that that's the case. Note thus that even in the dynamic of dual federalism, the relevant pattern of transnational coordination is not one of centralized de jure standard setting or defining of the relevant coordination equilibrium. Even in the dual federalism world, in essence, independent nation states are engaged in a process of fairly decentralized efforts at coordination. There is no, at least in most areas of transnational law, of international law, there is no centralized authority in a position to dictate the relevant coordination equilibrium, the relevant coordination result. So even in dual federalism, even when the only voice in foreign affairs is the federal government, we have this sort of decentralized, this more de facto or more market-based dynamic of coordination than a centralized de jure mechanism of coordination. When we add in local and state entities, in essence, then the pattern of coordination doesn't change. We, in essence, are still engaged in the same process. We might say it's a more complex dynamic of coordination because now instead of 50 states, 50 nation states being engaged in the process, instead we've got 50 nation states plus an array of local and state entities that are participating. But the fundamental dynamic of coordination, it seems to me, remains the same. And as Paul's paper points out, and as the standard-setting literature elaborates, coordination is quite viable. I mean, coordination is a real prospect and possibility, even in these decentralized circumstances, even in the absence of any centralized mechanism of standard setting or coordination. So then, the shift from dual federalism to intersystemic governance doesn't change all that much about the external-facing dynamic of coordination in international law, but it dramatically changes the internal face. Remember that the internal story of coordination was about the national government, the federal government, using international law to, in essence, bring subnational entities in line. As we shift from dual federalism to intersystemic governance, however, local and state entities, as Judith described, are in essence participating in the design, the shaping, the definition of international law. So that story of international law as coercive, as controlling, as limiting, as constraining, falls away. The question then becomes, what account is to replace that? Here I would say, well, what we're left with is the externally facing dynamic of coordination, the externally oriented or directed dynamic of coordination. And if that's the case, we end up with what I suggested at the outset, a dynamic in which international law increasingly can be understood, at least in select areas, I should emphasize. At least in select areas, international law can increasingly be understood as a mechanism by which state and local entities are empowered. That may be too hokey, postmodern or something, but a mechanism by which an opportunity for state and local entities to engage with sets of policy issues, with policy questions that they otherwise would have been excluded from. In essence, they provide, international law and international institutions may increasingly provide an additional venue for state and local entities to participate in transnational policy lawmaking. To conclude, just a quick couple of words about what this pattern might mean for the actual dynamic at work. In the paper, I briefly note 3 points of reference. First, I mentioned Canada. Duncan pointed out earlier that Canadian provinces can't directly negotiate. It's my understanding that Canadian provinces, at least in the international trade context that I know well, are quite participatory, are quite actively involved in the designing of Canadian international agreements, treaties, and so on and so forth. So in some sense, we might expect the United States, as we move from dual federalism to intersystemic governance domestically, to look more and more like Canada transnationally. First point. Second point is that a particular area in which we might see these opportunities for greater state and local engagement is in areas of transnational standard setting, and perhaps particular in areas of environmental regulation and public health and safety regulation. These are two areas in which state and local law speak quite substantially to the relevant issues being analyzed, regulated, and for which these standards are being established transnationally. As a result, it may not be surprising that increasingly transnational efforts at standard setting incorporate and integrate a place for local and state participation. Finally, in the paper, I mentioned the fascinating and ongoing dynamic of the Medellin case, suggesting that the case might fairly be read to be consistent with the traditional account, to be consistent with the notion of international law as limiting state and local influence or power, but that perhaps it might also be read as the case might also be understood as a case in which local and state, or in this case state entities, are being given a voice that they did not have, that they lacked previously. Paul has elaborated on the Medellin case, however, in far greater detail than I do in the paper, and that I plan to. So let me stop there and turn it over to him to take that up. Thank you.
Okay, so I am the fourth in a quartet of voices, including Janet Levitt in her comments this morning, and Judith Resnick and Bobby just now, continuing this line of sort of de-essentializing the definition and boundaries between or among the domestic, the local, the national, and the international. Since Bobby quoted me, I'll quote him back. I agree with him in his prior work that lawyers spend a lot of time, and perhaps rightly so, on line drawing and on trying to categorize and on trying to police boundaries. And to the extent that there's jurisdictional overlap or confusion or uncertainty, lawyers and legal scholars tend to bristle at that and to see chaos, and to try to find ways of determining an answer, and then arguing back and forth about what the proper answer should be. I agree with Janet from earlier that whatever we say the answer should be is unlikely to be actually how it works out in the world. As Judith said earlier, no court pronouncement, no scholarly pronouncement is ever going to be the last word on the question anyway. And the real world is full of blotches, blurs, overlaps, and uncertainties. And the effort to try to keep apart the boundaries of what's permissible and what's not permissible, what's national and what's domestic, what's international, is probably a fool's errand. In addition, it seems to me that an alternative account could be offered that looks at the potential advantages that come from embracing a more complicated and more overlapping and less essentialized world. In sort of the language of computer science, to treat jurisdictional overlap as a feature and not a bug of the system, something that actually could have benefits and not just be something that we want to get rid of. And I think, parenthetically, that it's not surprising that all four of the people I just mentioned are and have been throughout their careers quite strongly influenced by the seminal and extraordinarily creative work of Robert Cover. That's not a coincidence, and it seems to me that, just parenthetically, that international law scholars and scholars of American foreign relations law could do well by revisiting Cover's work, even though he didn't write about international law that often. It seems to me that he has a lot of lessons, and I've been arguing over a number of years that international legal scholars should go back and read and use Cover, and hopefully that will happen over time. My alternative account comes from legal pluralism, of whom Cover is one, but there's a group of legal anthropologists, political theorists, and other scholars going back at least 100 years in a number of different disciplines that have looked at legal pluralism, and that is the existence within the same social field of more than one legal or quasi-legal system. And so that, as we sit here, that could be the laws of Missouri and the laws of the United States and certain international laws and so forth. Legal pluralists go farther and look at non-state legal communities, religious law, canon law, Sharia law, etc., various ethnic groups, various business communities. How you define what's law gets into a whole big debate within legal pluralism that we don't need to deal with here. But the basic idea is that every legal system and every social system is constantly constantly exists with multiple overlapping legal entities and legal pronouncements. Although legal pluralism is largely has been largely a descriptive enterprise, they've sort of, anthropologists have looked at the existence of, indigenous law and colonial law and the way in which they overlap each other, they intertwine with each other, actors strategically use one against the other or to gain certain leverage within various systems by using other systems and so on and so forth. That's been a descriptive enterprise. It seems to me that following Cover, who, after all, wrote an article called The Uses of Jurisdictional Redundancy, that we might actually see advantages to these multiple overlapping jurisdictional authorities. One is that, and some of these are repetitive of some of the ones Bobby was just talking about, allows multiple ports of entry. So there are, to the extent that there are multiple authorities or regulatory bodies, there are multiple places people can go to try to gain purchase within their local polity. Therefore, secondly, there's a greater opportunity for norm articulation by multiple different entities who can weigh in and try to affect local debates, gain political power, and rhetorically persuade people and perhaps change legal consciousness over time. A corollary to that is it therefore empowers multiple communities because people who are shut out in one jurisdictional system may have an opportunity to speak or be heard in another system. It allows for multiple possible solutions to a similar problem. This is sort of the states as laboratories of innovation kind of idea, that we could, that the more people who are addressing a problem, the more possibility that we could have innovative and creative solutions, or that bad solutions will get criticized or rejected elsewhere. It also, and this, I don't know if this is an instrumental benefit or a benefit in and of itself, but it encourages decision makers to take a more restrained view of their own power. So that when judges or any other decision maker choose one path over another, what Cover referred to as acting jurispathically, killing other interpretations of law in order to pursue this interpretation of law, if they are thinking about sort of a multiplicity of lawmaking bodies, they will have a tendency, one hopes, to take a more restrained view of their own jurispacific power and only exercise it when they can justify doing so, as opposed to doing it because, well, I'm the law, and so I'm just going to rule, and have no sense in which I relate to a broader set or web of interlocking systems. Now, as I said, I think as a descriptive matter, pluralism simply captures the way international and transnational assertions of jurisdiction work, often better than the rhetoric of sovereigntism, and I agree with Judith on that. Just as, one example, there was huge uproar about Spanish Judge Garzón asserting jurisdiction over people in Argentina who had been accused of human rights violations during the military junta there, that this is violating Argentina's sovereignty. Argentina had made a sovereign choice to grant amnesty to all the people from the military period, and so this was undermining that sovereign choice. But of course, Argentina is not a single entity with one set of interests or one set of choices. The choice to grant amnesty was a contested one within Argentina itself. And one of the things that Garzón's decision did is it empowered local actors, in particular the incoming president, Nestor Kirchner, to galvanize popular action within Argentina, and ultimately to get the amnesty laws repealed. And so what the transnational assertion of jurisdiction did is it changed the internal dynamics of power and the rhetorical arena in which the political debates took place. And that kind of an analysis, I think, doesn't get captured in a, here's a sovereign choice and here's an imposition on that sovereign choice. So that's as a descriptive matter. So might we tease out some normative lessons from pluralism, from this idea of overlapping jurisdiction? Well, so we could ask decision makers not to try to resolve line drawing problems, and not to try to police borders, disciplinary borders or jurisdictional borders in an incredibly formalistic or strong way, but partly because it won't be successful anyway, for reasons we've discussed, but also because it might be beneficial to leave space for more iterative dialogue over time rather than cutting off that dialogue. This goes to the, instead of having a foreign affairs preemption, you leave space for at least, sometimes yes, maybe sometimes no, but then there's more space for discussion. We might also see an engagement with multiple lawmaking communities so that decision makers don't only think of governmental entities, but also think of epistemic communities that might be relevant to a particular dispute, but who, for whatever reason, aren't literally present before it. We could, as a corollary to that, recognize multiple community affiliations and understand that there may be multiple levels of government or non-government that could speak to an issue and that might relevantly speak to an issue that you might want to defer to sometimes, or listen to at the very least, or justify if you're not going to listen to. You might pay more attention to what some people in the conflicts of law literature refer to as conflicts values. The idea that there might be an independent set of values to trying to act in dialogue with other decision makers, and that might be a value independent of the actual decision. So, for example, our full faith and credit clause asks courts in one state to enforce the judgments of decisions in another state, even if those judgments would have been illegal if issued by the second state. And the reason that we do that is that we think, or at least it's been argued, that there's an independent value to this idea of paying attention to what other states say and not allowing people to just cross borders as a way of avoiding judgments they don't like, or maintaining multi-state harmony, or all of those kinds of values, that those are independent values over and above the actual merits of the decision itself. And so a focus on jurisdictional overlap may effectuate that kind of a benefit. And to the degree that deference is overcome, that is, if you don't follow some other legal statement, or if you don't enforce another entity's judgment, if you act jurispathically in that sense, you need extra justification to show why it's true. In the conflicts setting, that would be something like a public policy exception, which again is an exception and needs to be argued for. All right. So what would be, so how would that work out? Let's take an example. You could build these sorts of things in structurally. One very quick example. The European Court of Human Rights has a doctrine known as the margin of appreciation. Controversial doctrine. It's usually seen as a necessary but regrettable compromise on both sides. The idea is that rather than sort of a hierarchical imposition of a new human rights norm, there is an articulation of the norm, but a space is left for state entities and state constitutional courts to apply that as, with a little bit of wiggle room. And, hardline internationalists say, oh, well, we had to do this as a compromise with these recalcitrant nation-state sovereigntists. Nation-state sovereigntists say, well, we had to give up some authority to the international, but at least we kept this. And both of them sort of see it as a half-a-loaf kind of solution. From a pluralist point of view, it might be seen as a loaf-and-a-half solution, because it creates structurally a point of dialogue, tension, and opportunity for back-and-forth iterations. And so we might actually see that as a benefit. All right, so how might Medellin be approached using these principles? if we thought about it in a completely different way through this pluralist lens. So the International Court of Justice, issuing a decision about what Texas should do in this death penalty case, doesn't win just because it's international. It's not a hierarchical imposition. It needs to, if it's going to squelch or kill off a local law, like a local procedural bar, would need to, for example, justify doing that, paying attention to the alternative communities that might exist and that might be relevant, and should allow as much space as possible for the local to be given voice. So, what does the ICJ do? It actually goes through a tremendously long justification for why it's acting as it is. It does pay attention to communities within Texas who might care about reciprocal consular rights, U.S. citizens who travel abroad, potential immigrants who may be reluctant to enter the country. It's also interesting that even within Texas, the Texas Attorney General had already implemented a comprehensive set of reforms at the local level to try to implement the Vienna Convention. So again, Texas is not one sovereign entity with one set of interests here. And then, in addition to justifying it, the ICJ also provided some space. It didn't overturn the decisions altogether. It merely said that Texas needed to hold a hearing to determine the existence of prejudice. Texas, well, the ICJ decision may not be literally binding, but no need to ignore it. Treat it as a judgment recognition decision. Maybe there are public policy objections to certain international interventions, but there's no reason to say that they're necessarily blocked by their procedural default rule, because the decision to enforce the ICJ judgment, just like the full faith and credit clause idea, implicates a different set of values. Particularly important in this case because the procedural default rule, general procedural default rule, is generally not going to be focused on the multi-state implications of this particular case. And as noted, the ICJ wasn't actually asking Texas to do that much, and also went out of its way to try to justify what it did do. So it seems to me that from a pluralist point of view, it's a relatively easy case. There may be hard ones down the line, but I would say this one is fairly easy in favor of Texas holding that particular hearing. It also means that the U.S. position is wrong both ways. First, that the ICJ decision is completely inapplicable to states. I would say it is applicable, at least in the judgment recognition sense of the word. And secondly, the assertion of a kind of foreign affairs preemption, and for reasons that Judith already mentioned and that I averted to, a pluralist position would be opposed to a kind of strong foreign affairs preemption that just says, well, since the executive tells Texas to follow it, Texas has to follow it. So, to conclude, both, this is sort of just a thought experiment, but it seems to me that both the international law, sort of international versus domestic, and should we cite international law and all that kind of stuff, those debates tend to be too trapped in the language of sovereignty and too trapped. I would embrace, by the way, the broader conception of sovereignty that Judith talked about, but too trapped in a very narrow conception of sovereignty, and too trapped in trying to do a very formalist line drawing, and that our federalism discourse has tended to do the same. And that instead of that, and instead of sort of bemoaning the fragmentation of law or the multiplication of law or the variety of sources or the amount of border crossing, etc., we should accept them as a necessary consequence of the fact that communities cannot be hermetically sealed off from each other, and they never have been. Certainly in an era of globalization they're not, but it's not clear that it was ever anything different. Now, so the Medellin case will be decided by the U.S. Supreme Court, but as was already discussed, a decision is only one step in this ongoing iterative process, and so it's not going to be the final word. The conversation will go on, and interestingly enough, the Vienna Convention and the ICJ decision will continue to have an impact, regardless of the Supreme Court, because local law enforcement authorities around the country are now cognizant of their obligations in a way that they weren't 10 years ago. The State Department has a consular notification and outreach division. Pluralism recognizes, therefore, the tangible day-to-day ways in which international law is brought home, sometimes regardless of official legal pronouncements. And, by the way, we saw in Oklahoma, as discussed earlier by Janet, that, sometimes courts could really embrace what is essentially a pluralist way of looking at the problem, and thereby do it even as a matter of official law, let alone these less official ways in which international law gets effectuated. Most fundamentally, it seems to me, all of that interaction is elided or ignored if we continue to speak and think in this language of demarcation and formalistic conceptions of legitimacy, what's allowed, what's permissible, what's okay, what's not okay, and so forth. It seems to me that instead of that and insisting on sort of pure theoretical models or constitutional interpretation models that tend to be divorced from what's actually happening on the ground, we could accept and perhaps even celebrate the potentially jurisgenerative and creative role that law might play in this plural order. Thanks.
As the last person to speak at this conference, I'd like to join everyone else in thanking Peggy McGuinness and the University of Missouri Law School for a great job they did in organizing all of this. I guess I'm also conscious that I'm keeping you perhaps from your reception and food and other pleasantries. I will try to keep the remarks brief. However, you know that whenever a law professor says something like that, that's a sign that they'll run over their time, so I can't absolutely guarantee that that won't happen. This is a paper, beside a title, about voting with your feet, so it's kind of ironic and unfortunate that the production of this paper was inhibited by the condition of my own foot, namely that over most of the last 2 months I spent recovering from ankle surgery. The paper, unfortunately, is not as thorough and complete as I would like it to be. However, through the intersystemic dialogue that we're going to have here, hopefully I will be aided in the task of revising and completing it, particularly since, unlike most of the other panelists we've seen today, I come at this not as a scholar of international law, which I frankly for the most part am not, but as a student of domestic federalism. This is perhaps scholarship from domestic federalism reaching out, perhaps imperialistically, even into the international law world, rather than vice versa, similar to what we've seen in the previous panels. However, in my previous work in this area, which was all at the domestic level, one of the things I've always been most interested in is the potential benefits of voting with your feet as counterbalanced as an alternative to ballot box voting. That is, that if you don't like, for whatever reason, the policies of your own state or your own local government, one option that you have is you can go to the polls and try to vote in a new local or state government that will change the policies. But another option is you can vote with your feet, you can leave your current jurisdiction and move to another one with more favorable policies. And the literature in this field, which is at least 50 or 60 years old now, has pointed out several major advantages that accrue to having free migration within a federal system that enables people to vote with their feet. Another set of terminology for it is this exit as opposed to voice, following Albert Hirschman's famous distinction. It occurred to me in thinking about this that these major benefits of voting with your feet exist in some ways to a much greater extent for free international migration than for free domestic migration in a federal system. And this paper is devoted to expounding what I think are 4 of the major benefits of voting with your feet and showing how at least 3 of them, and possibly all 4, are even more applicable to international migration than to domestic migration. So in the first part of my presentation paper, I'll talk about the 4 benefits and how they apply to international migration. And in the last part, I'll talk very briefly about some implications for actual law, namely the international and domestic law of migration. Now, I want to highlight a very important limitation of my analysis right off the bat, and that is that sadly, I know it'll be disappointing perhaps to some of you, but this is not a comprehensive theory of the costs and benefits of allowing or forbidding international migration. I will not be presenting to you a theory which says, well, this kind of migration be permitted and this kind forbidden. Rather, I'll be presenting you some considerations from the voting with your feet literature that should impact that determination, but I make no claim that those are the only relevant considerations. However, I do think these advantages of voting with your feet are quite large, and therefore, if there are countervailing considerations that balance them or to outweigh them, I accept that there might be, but those considerations should also be quite powerful to overcome what I'm going to suggest are the fairly large benefits of allowing free migration and voting with your feet. So before moving into the specific benefits, I do want to make one overarching point about the distinction between international and domestic migration, and that is that with domestic migration, at least in a liberal democratic state, there is the alternative option of acting through the ballot box. So if you don't like Missouri's policies, you kind of lobby for change in Missouri rather than necessarily right off the bat moving to Texas or California or something. For about 50% of the world's population that lives in non-democratic societies, that is not true. They don't have a ballot box option, and short of the violent overthrow of their government, it may be that voting with their feet is the only option that they have to influence the content of the government policies that they choose to live under. And that is a very important general point about the advantages of international voting with your feet that make them perhaps greater in the advantage in domestic context. So the first of the four more specific points I want to talk about is simply choosing policies to fit your own preferences. This, of course, is the basis of the Tiebout model developed by Charles Tiebout more than 50 years ago, where he pointed out that people have different preferences for how much, if any, of a particular public good that they want, and one way to enable more of those preferences to be satisfied is if people have free mobility in a federal system and can choose to live in a jurisdiction that most closely fits their preferences, and through various mechanisms, I'm not going to describe in detail in the presentation, but that I do talk about in the paper, you can get more people's preferences satisfied through free mobility than simply through each group of people only being able to lobby in changing their local policy. Now, he spoke of public goods, but as I note in the paper, a similar point applies even to the production of private goods by local and state governments. Now, in the international arena, I think this benefit is potentially even more true in that there's far more diversity of policies across the world's 190-plus nations than there is across state or local jurisdictions within any federal systems. If you take the two most divergent U.S. states, they diverge from each other much less than the United States diverges from Sweden, and the difference between the United States and Sweden itself pales in comparison with the difference between, say, the U.S. and North Korea, or even most first world nations with most third world nations. So given the vastly greater diversity that exists in the international as opposed to the domestic arena, there is potentially much more room through free international migration for satisfying diverse preferences than through domestic migration. Now, it is true, as I noted in the paper, that in the international arena, moving costs, even if legal rules don't inhibit migration, the moving costs may be greater than they are in a domestic arena, and that obviously is some obstacle to this. However, on the other hand, the moving benefits are also often vastly greater, in particular when people move from the third world to the first world. In most cases, they can expect a massive increase in their wages almost immediately that will often be more than sufficient to offset the cost of moving. That will not, of course, be true for every single person, or even perhaps for the majority, but it will be true for a very substantial number of people, and therefore quite large gains in this area can be expected from free or even relatively free international migration. Now, the second and closely related advantage of free migration within a domestic federal system that the literature has concentrated on since Tiebout, but even somewhat before Tiebout, is the advantage of interjurisdictional competition. That is, local and state governments often want to attract migrants and businesses because they want to increase their tax revenue, and similarly, they want to prevent taxpayers and businesses from moving out so as not to lose revenue, and that in turn gives them incentives to forge policies in such a way as to make the jurisdiction attractive to people who will move in and increase tax revenue in that way. I think this is true to some extent at the international level as well, and you do see efforts, for instance, by European countries in recent years to try to alter their policies to reduce what they see as the brain drain of some of their most talented people to the U.S. and also to countries like Ireland and Australia. You also see policies of this sort being enacted in some Asian countries and elsewhere. At the lower end of the economic spectrum, there are many examples of countries setting up guest worker programs for low-skilled workers to attract workers to boost their economy in that way as well. It is true, however, that in this area, unlike in the other three that I talk about, the incentives in the international arena, even with free migration, may not be as strong as in a domestic arena, namely because in many countries, including sadly, in my view at least sadly, in the United States, immigration is often quite unpopular politically, and indeed, the economist Brian Kaplan, in an excellent recent book, has identified what he calls anti-foreign bias. That is, it seems to be systematically true that public opinion in most, if not all, nations tends to systematically overestimate the harms that foreign immigration causes and underestimate the benefits. So this anti-foreign bias will to some extent reduce the incentive of nations to compete in a way that will not be as often observed with respect to competition between states in a domestic federal system. However, even with anti-foreign bias, there is still some incentive to compete, and moreover, with almost 200 nations out there, even if only 10 or 20% of them are motivated to compete, that's still quite a few potentially important entities competing in this arena. So while the incentives might in some ways be weaker than those in the domestic system, the potential benefits might be as large or even greater because of the greater scope of the competition and the potential benefits of diversity and policy in this respect. Next is a point that I think is not as fully developed in a theoretical literature on federalism, but is certainly out there, and I've talked about it somewhat in my work, and that is the potential for protecting repressed or oppressed local minorities through movement. In United States history, I think the most important example of this is the movement about 100 years ago of African Americans from Jim Crow southern states to the northern western states. Obviously, African Americans, especially in that period, were severely oppressed in the southern states, but were able to move to other states where the policies were at least relatively more favorable and thereby greatly benefit themselves. In the international arena, I think the potential benefits of this kind are even greater because in many countries you observe such great oppression of racial or ethnic or other minority groups that it pales, that it's vastly greater than anything that you might observe in terms of local oppression in liberal democratic federal societies. So I'm not going to dwell on this point too long. I think it's obvious that there are potentially huge benefits here through free international migration, and in fact there are many historical examples of this. Lastly is a point that I've emphasized in my own scholarship, though it hasn't yet caught on as much elsewhere, and that is the advantages of voting with your feet as a method for incentivizing people to acquire information about better policy alternatives. When you vote at the ballot box, there's a serious problem of what scholars call rational ignorance. That is, there's very little chance that your individual vote will actually make an impact on the outcome of an election, and therefore you have very little incentive to acquire information about public policy just to be a better voter, and you also have very little incentive to rationally evaluate whatever information you do acquire, because after all, even if you do a great job of evaluating it, still the chance that your information acquisition will have an impact is extremely small. On the other hand, when you vote with your feet, your decision will usually be individually decisive, or at most, maybe you have to consult your other family members or relatives, and so the incentive to acquire information and rationally evaluate it is much stronger than with ballot box voting. I think this is true for domestic migration in a federal system. In some respects, it will be even more true for international migration for two reasons. One, as I've already noted, many countries in the international arena are not democratic at all, so there's no ballot box incentive to acquire information at all in those countries. Second, even in countries which are democracies, if you look through the third world or lesser developed countries, there's many nations with a large proportion of population that is illiterate or extremely poorly educated, and for them, it's often much easier to acquire information relevant to foot voting than information relative to ballot box voting, and so the benefit there will be greater perhaps than with the relatively more educated people of the first world, of the United States and other similar countries. I guess in my last few minutes, I want to briefly focus on some of the implications for international and domestic law. Necessarily I have to paint with kind of a broad brush. I only have a couple minutes, but I at least want to make a couple of general points. One is that current international law already does have pretty strong norms for rights of exit. That is, countries are generally required, at least in theory, to allow their people to leave if they want to. I think that's good for the reasons I've elaborated so far. On the other hand, there's much weaker norms for allowing a right of entry. Usually a right of entry is required only if there's some very specific type of oppression based on race or ethnicity or the like, and even then, you're not actually required to let the person stay permanently. What you're required to do is not kick them out, or not immediately kick them out if they make it to your territory. And a point I make in the paper is that while exit rights are great, their value is limited if they're not coupled with entry rights. After all, it may not be of great value to be able to leave your country if you can't go anywhere else. And the considerations that I point to in the first part of the paper in my presentation suggest that stronger entry rights might be desirable, especially in light of the anti-foreign bias that I mentioned and in light of the fact that domestic political processes in entering states will often have little incentive to consider the welfare of the migrants. Now, that is not to say that even in the ideal world we would have complete open borders with no restrictions whatsoever. Obviously, to fully make that determination, I have to consider a lot of things that I can't possibly take into account in this paper because those things would then swamp the points I actually do want to make. Second, even within the foot voting model, there is at least one consideration that may sometimes counsel in favor of limiting migration, and that is there might be situations where a certain group of immigrants, because of their illiberal or anti-democratic or other harmful views, if a large number of them move in at once, they, through their political power, might potentially destroy the liberal or other institutions that make the country attractive for migration in the first place. Now, I think in the real world, this situation is only relatively rarely likely to arise, and so I think a lot of the people who raise the specter of this possibility, I think, are probably empirically inaccurate in particular cases. However, that doesn't mean that it can't happen theoretically, and that also doesn't mean, therefore, that the foot voting analysis that I put forward, even on its own terms, always counsels unlimited migration rights. However, even though, therefore, I can't present you with a comprehensive theory of migration rights, I do think that I can at least present you with considerations that counsel in favor of broader migration rights, and in some cases quite strongly. After all, in terms of choice of policy, the benefits are quite large in terms of protection of minorities and other groups, perhaps even larger, and you could quite literally save the lives of hundreds of thousands, if not millions of people, and make a still larger number of people vastly better off economically and socially. So I certainly do not at all want to foreclose the possibility that there might, in particular cases, be other considerations that outweigh this. I think actually, at least in some cases, they will outweigh it. However, they have to be quite important considerations, important enough to draw a major distinction between movement across domestic boundaries, which almost everyone seems to agree should be free, and movement across international boundaries, which people are much more open to constricting, but which I suggest many of the same considerations that work in the domestic context also will operate in the international one. So on that note, I will conclude, and I look forward to the commentary, and also to your questions, of course. Thank you.
Well, I think the breadth of these papers testifies to the power of Missouri versus Holland as a useful launching off point, although at least two of the three papers don't even cite Missouri versus Holland. And I think Bobby maybe just did it out of, you thought it was blunt, right? So it actually just, so actually it may just testify to Peggy's, her wisdom in selecting the authors and others here. And I think actually one thing that's unusual and particularly valuable about this gathering is that she's brought together two groups that don't always or often talk to each other, that is the foreign relations law folks, and then I guess a group that I'm not sure has a name yet, but maybe as Janet puts it, sort of a more socio-legal approach to these questions, which would include Janet and Judith and Bobby and Paul, and I think obviously these two groups have a lot to learn from each other, so even if it's not interdisciplinary, at least interfield in a way that mixes things up in a very stimulating way. So, to start, I have just two, I guess they're in the way of challenges for the paper writers for this panel. And for the first one, I want to put on a hat that maybe isn't represented here, and that's more just the straight international law perspective on these things. And the way I'd frame the challenge, and I don't usually put myself in the position of an international law triumphalism, and I'm very sympathetic to the non-essentialist approaches that have been represented so nicely here. But the way I'd frame the challenge is really, how do we account for or allow for universalism? So we've got Paul who wants legal pluralism and warns us against the exercise of jurispathic powers, of killing off normative commitments, and of highlighting mechanisms such as the margin of appreciation, which allow us to stay away from universalistic approaches. But I wonder if that's always going to be possible. So in Medellin, you've got the gloves on, but there are going to be cases in the future where they're not, and where whatever community is being targeted by a particular international institution is not going to have the wiggle room, where there just are rules, where there are constraints that the community has to knuckle under to. Same comment with respect to Bobby's notions of inter-systemic governance, in which he highlights mechanisms of coordination, which can lead to harmonization, which in turn, though, can lead to hard international law regimes, which can be constraining then on subnational entities and other communities in ways that may not be empowering, even though the subnational communities may have participated in the formulation of these regimes. And then for Ilya, I assume that it's more a question of whether we allow for universalism. To the extent that we have the virtues of federalism at the international level, in effect, I'm assuming, although this would be a question, that he would be resistant to any forms of universalism. And then one can, the easy question is, what do you do with those forms of universalism that we already have? So you've got Hughes Kogan's norms that are established. How do you live with those to the extent that it prevents people from voting with their feet? And whether we think of them as Hughes Kogan's norms or just hard rules of international law, this is likely to be, this universe of universal norms is likely to be a growing one insofar as all this stuff is percolating up. I think we can avoid this kind of focusing on this question at this point in time, to the extent that it's very unstable, and lots of these norms regimes are still in their infancy. But if we look down the line, as these regimes harden, Judith pointed out that corporations are now pressing for national regulation because it gives them certainty, even if it means in some cases they risk the substance of rules that go against their interests. Corporations are now also pushing for international regimes, including, for instance, in the climate change context, so that, and to the extent that we start having money and power pushing for hard international regimes, we're likely to see more of them. Now, we could tie this back into Missouri to the extent that Missouri can be framed as a means to universalistic ends, along the lines of David's comment in the morning, especially to the extent that we're now in an era of near universal treaty regimes. So, although there may be other means to these universal ends, including the ones that we find coming from this new school of international law. And so the question is, how can we systematize the establishment of universal norms even if we do it from a more socio-legal perspective, or for that matter, from a more formal, one of a more doctrinal or formalistic approach. So that's the first challenge. The second one, which is admittedly adds yet another layer of complexity at a late hour in the day, but it takes off from, especially from Paul's work, I think. At one point in his paper, he asks, how are communities appropriately defined in today's world? And in all of our discussions, and of course in the case in Missouri versus Holland itself, there's an implicit privileging of territorial communities. That it's territorial communities that are ultimately in charge. And this is certainly the case in Ilya's paper, where with this concept of foot voting, which creates a sort of interesting image, voting with your feet. But I mean, especially in Ilya's paper, not intended, I know, but that it implies that governance is on an exclusively territorial basis, that you can move from one regime to another, and by moving from one piece of territory, crossing a border, you're then entering into a completely different governance regime. And I guess I just want to question that, and here I'm wearing my hat as a sometime theorist of citizenship, and this also works from one of Judith's comments in the Q&A period, that there's nothing natural about the state. There's nothing natural about the nation state, and I'd also recommend the book by Emory, which is a wonderfully elegant and eloquent discursus on what future we have for the state. But one could also extend that, and to some extent what we're talking about with Missouri versus Holland, of course, is the relative force of two forms of territorial community, and whether we're going to privilege one over the other, and that's the discussion that we have in all federalism issues. And I think we can start to bring the nation state into question. I think we might also be able to bring the states into question as privileged communities going forward. It's interesting that the focus of a lot of Judith's description is really local and not state. And and states, as in the states of the United States, are also essentialized, at least to the extent that they get beyond the provision of electricity. I mean, at some level, obviously, our existence is spatial. It's physical, and so physical communities at some local level, I think probably are essential and natural. But once one gets beyond the local level, and especially once one gets into communities, the boundaries of which are quite artificial, along the lines of our thinking about space, that we can at least bring them into question. And one way of posing the question is to do it in terms of identity. So, how strong is our identity as Americans, or whatever nationality we have, or the multiple nationalities that we may hold? And then ask the same question about how strong our identities are as citizens or members of communities defined along state lines. So, Missouri, these obviously are variable quantities, but how strong are our identities as Missourians or Pennsylvanians or whatever you call people from Connecticut? So, and then what happens? And so I don't think that we can necessarily bracket the force of non-state communities. And here, obviously, you add a lot of extra complexity into questions that get us pretty far removed from Missouri versus Holland, but questions which, if we look at these issues in a global context, can't be avoided, because we're talking about communities that are legitimate ones and which do define people's identities. And here, I just one point taking off from Ilya's paper, that there seems to be an assumption in his foot voting scheme that we're all atomized, rational individuals, that we're free agents, and that if we move from one country to another country, we don't take any community associations with us. But that's obviously not the case. Interesting phenomenon in the massive wave of immigration in the last decade to the United States with respect to diaspora communities, where they in effect take their homelands and bring them to the territory of the United States in a way that, much more so than the policies of the United States government or of state governments, affects the everyday existence of individual members of those diaspora communities, which in turn, I think, also points to a hollowing out of territorial instruments of governments to the extent that community identity and association becomes portable. So those are the two questions that I put on the table: universalism, and then the possibility that territorial communities are not the only way in which we're going to be defining ourselves going forward, with all sorts of implications for the future of governance.
Thanks. I'm sort of feeling, I think, a little bit like Peter in terms of reaching the conclusion that there was a certain voice missing today. And I sort of scrapped my original comments because I wanted to talk about the essentialism of public international law. Or found myself, sort of leaning in that direction. So, I would have said what Bobby said, ditto to what Judith said, ditto to what Bobby said, ditto to what Paul said, but for this day, and thinking about the ways in which the doctrinal domestic questions come into connection with and intersect with traditional public international law. So I'm going to, I'm going to talk first about Bobby and Paul's paper and raise a couple of questions, and then talk about Ilya's paper. I have great sympathy for this project, pluralism, socio-legal approaches, transnational legal process, intersystemic governance, particularly as a descriptive project. I think there's just not enough going on in terms of explaining the complexities and describing the complexities of these multiple legal orders. And so I'm extremely sympathetic to this approach. So I was wondering, why am I throughout the day thinking about why is it a problem to essentialize the international? What's so bad about public international law? So let me offer a sort of counter-narrative to the Medellin case, which I've written a lot about, that offers an international human rights perspective on that case, which I think raises some questions about pluralism and raises some questions about the applicability of Bobby's theory of intersystemic governance. So there's a story that you can tell about the ICJ and the Supreme Court's enforcement of the ICJ opinion or non-enforcement of the ICJ opinion, and you can tell this story about compliance with Article 36 of the Concert Convention, which is the notification provision. The story that I think is the real story is the story about the contestation of the death penalty rule or norm, which is to say that it's not a vague or aspirational norm in the sense of the treaties that Carlos was talking about earlier. It's pretty clear. Optional Protocol 2 of the ICCPR abolishes the death penalty. All right, it's a very clear norm. It's a norm to which the United States has been a persistent objector, along with a couple of other states. And so if you tell the story from this perspective of the international norm, I start feeling like the actors in the story maybe lead to a conclusion of a more international law essentialism and more of a traditional place for statehood, not sovereignty per se, but statehood, and I'll talk about that in a second. So you can think about this as an account of, coming a bottom-up kind of transnational advocacy entrepreneurs seizing on a case in Texas with a Canadian national with the assistance of the Canadian government trying to stop him from being executed. What happens along the way are, these activities by nation states, in particular Mexico, Canada, Germany, Paraguay, acting as states in traditional roles of statehood through traditional international law mechanisms, right? Going to the going to the Inter-American Court of Human Rights, going to the International Court of Justice, petitioning the State Department, engaging in traditional state-to-state diplomacy. Yes, other things are happening too. They're also engaging in direct diplomacy with the states. They're engaging in direct conversations with governors, and they're also acting in these sort of coordinated roles with NGOs, which Judith was talking about, where you've got states acting as advocates in their own right. But it is the mechanism of traditional public international law, this idea of consular and diplomatic protection, that enables the states to do this, essentially, on behalf of what has become, to my mind, a very firm norm in international human rights law against the death penalty. Okay, so that's sort of the other story there. And I've argued that this, the Consular Convention in this case represents this sort of norm portal, not a port of entry generally, but a portal for norms, for law, for legal rules to enter into the system and to be contested at certain points in the system. And part of the reason I use that term is because I'm interested in finding out how these clear norms that are out there in the international legal system actually are given effect by states, and in some instances non-state actors. So I'm concerned with the I love the Pluralism Project, except for this question of the content of norms, right? So, so when Judith says entities can be a thing or another, my sort of response is, but norms sort of can't. I mean, sometimes norms evolve and change over time, but there are rules. There are legal norms in the international system, and I wouldn't want to think of them as being one thing or another. I think of them as being what they are. Also, this idea of the contestation of norms in these hybrid spaces that Paul talks about, one of the things to remember is that the international legal system, at least I've always conceived of it as not a neutral system at all, right? It has a normative agenda, at least the post-World War II international legal system. Bias towards peace, right? Abolition of use of force as a means of dispute resolution, and the International Human Rights Project. And those are the two normative pillars. So if we think about those as just other norms to be contested, the international versus the local versus the state versus the national, it seems to de-essentialize international law in a way that, I mean, I agree that this goes to the universalist project of international law, right? So if we think that there's a universalist project, I have concerns about what the sort of pluralism approach to norm contestation does to that project. By the same token, I'm also concerned about these spaces of contestation, right? So what are the appropriate spaces? And this raises questions, for example, of the distinction between political and legal spaces. Goes to doctrinal questions, just justiciable questions, non-justiciable questions, self-execution versus non-self-execution. In a system of law that we want, again, the international legal order to be transparent and to some degree have enough formalism that we can navigate it to vindicate these normative goals of the international system, it's important that we understand how these spaces operate, and perhaps there is room for preferencing certain spaces over others. Okay, and so Bobby talks about, I think Bobby's approach to intersystemic governance on the international level works for everything but the human rights regime. And that's because of the classic, the human rights regime is not about coordination problems, and except for some minor exceptions, it's not about cooperation problems. We can talk about refugees and trafficking of humans and the Geneva Conventions, but generally it's not about those two sort of classic problems. And so you have these four, I scrapped all my comments. You had these four claims, Bobby, about the facets of regulatory design, jurisdictional overlap, dynamics of coordination, patterns of dependence, and the growing role of persuasion. I mean, the human rights regime doesn't seek innovation. It doesn't seek solutions that are different. It seeks for states and non-state actors to a certain degree to comply with pre-established norms. So again, I'm not sure how we could think about mapping that to the international human rights regime, which is what I'm thinking about a lot lately. So on the external-internal question, I do think that there is something there that we can think about for the human rights system. So when you talk about this sort of, the external spaces, the external leading to the internal contestation. Right, so in international human rights, you have these external norms, which are frequently in periods of transition, the quid pro quo, right, terms of peace agreements, entry into regional or international clubs. which sounds a little bit more like when David Bullock was talking about the sort of straight internal cost in exchange for the external benefit analysis of entering into international treaties. At the same time, you have an international human rights regime that at bottom preferences, I think, the most local solutions, right? It's about these intimate relationships in some senses between the state and the individual. And so you have that internalization going on. So there is at that level, I think, some sort of coordination going on between the external and the internal, but not in the same way that it's going on in the economic sphere. Okay, so on Ilya's piece, again, I'm struck by the fact that there is a sort of, and it may be that you're not focusing on this, but there is a sort of shadow regime out there in international law, again, sort of going to the traditionalist doctrine here. We've got consular and diplomatic protection. And in a way, I think if we were to follow your prescription about voting with one's feet, there'd be some interesting and perhaps unexpected outcomes given these background regimes. And one way we can think about this is there's not just the migration of persons, or another way to think about the migration of persons as norms is to think about espousal of claims through nation states. All right, this is the traditional international law approach. So going back to the consular convention cases, right, we have an illustration in those cases, particularly the Mexico cases, where you have migration for a better economic result that leads to a poorer human rights result, right? You get a good job, then join a gang and kill someone, you're subject to the death penalty, I guess is the way the narrative goes. Better off you had joined a gang and killed someone in Mexico City because you wouldn't be subject to the death penalty. And this sort of migration for better economic outcomes but worse human rights outcomes is not unique to North America. I mean, think about South Asians in the Gulf states, right? They're not moving there because the policies of Saudi Arabia are more liberal than the policies of the Bangladesh government. To sort of misquote the president, they don't love them for their freedom, right? And it's likely also, I think, in the case, the example that you used from the civil rights movement, it's likely only a happy coincidence, and in some cases maybe not so happy, that the economic benefits of the black migration to the north coincided with relatively better civil rights conditions, you know, but see the race riots of '68, busing in Boston, and so on. So that wasn't a bed of roses either. But to the extent that you're lowering these barriers to entry for non-nationals, you might sort of perversely or interestingly, depending on your perspective, be increasing the power of the sending state, right? Because under traditional international law, the sending state gains consular protection, gains diplomatic protection, and sort of the power of that state, having all these nationals now congregated in the new jurisdiction, is correspondingly increased. And it's going to do so in an opportunistic manner, right? So that's exactly the story of the consular convention cases. Mexico, Paraguay, and Germany opportunistically tried to influence, and in fact did, in my view, influence death penalty outcomes across the states. So I think that's something to think about, these sort of unintended consequences of increased movement. And I think part of this is because nationhood still matters and citizenship still matters. Oh, I have to moderate, I guess, right? So you guys have time to respond. Let's see. You want to take a couple minutes each? Yeah.
All right. So I'll just say a couple of things quickly. To Peter's initial Missouri versus Holland reference, at least for me, I think what's interesting is, you know, the extent to which the discourse surrounding Missouri versus Holland is at least suggestive of this fairly bipolar or stark choice we're making. In that sense, that's the point of departure for me. It's the question that, and I think it does represent fairly effectively, but others, as you say, could do it as well. It does represent, in that sense, a useful point of departure for the analysis. So that's there. The question of how we account for universalism, which is, in some senses, captures the balance, a lot of Peggy's comments as well. So I'm torn. I will sort of respond, I guess, several ways. One answer is to say that, well, we can. The system can do it. You know, so take the most simple sort of institutional regime of that, perhaps, is the ICC's complementarity, right? So you've got a regime there that in essence, is one that is grounded in that the principle of universalism, but at the same time recognizes some, or sort of builds in some institutional and perhaps some institutional complexity, perhaps some story about the different communities you mentioned and whatnot, as a way to add texture, add additional layers to that universalism. So that's one answer, I guess. One level of an answer is to say that we can do it, that sort of it's consistent with this account. Is piece one. Piece two is to say that that even as I say we can do it, it seems to me we've heard in Judith's remarks and in some of the earlier remarks, and clearly in Paul and I's remarks, an acknowledgement that it's a more complex story, right? That there's a complexity to, there's a certain appeal to the is the power state or federal in a given case that you lose with the story that Judith described, that I'm describing, Paul describes, and others. So given that complexity, it seems to me, I sort of began to move towards some version of it can accomplish that, or it is consistent with the universalism and in turn with the international human rights norms. But the more complex we get, the more attenuated that becomes. The more it becomes, it can accomplish it, but not necessarily that it will accomplish it. Right, but it's consistent with it in the sense that it's not, there's no necessary contradiction, but it seems to me sort of it becomes more of a question whether it will in fact achieve it or not. Thus, for example, then when Peggy described some of the substantive norms, you said, it's not clear how it's applicable with human rights. And you said, the one that struck me more, the not coordination is more complicated, and I probably largely agree with, but it doesn't seek innovation. I don't know if that's right. So for example, group rights, we might think of as, being sort of a potential node of innovation in international human rights, a potential node, I should say, of innovation. Social and economic rights might be a potential node of innovation where we might find utility, and maybe in other contexts as well. But then that gets me to the next stage. So if I start with we can do it, and then when I go to we may be able to do it, at some point then the back end is a fairly high degree of uncertainty that ultimately sort of gets me to the point of wondering is the question right? Sort of are we asking the right question? So when Peggy, you said that sort of there is normative content to international law, I wonder whether ultimately the account of intersystem governance, and maybe I'll add pluralism in, but Paul can reject it. In some sense, is hard to reconcile with that. That in essence, sort of, it forces us to, or at least presses on that conception of it presses on the concept of universalism, the concept that there is normative content on which we have all signed up. And that, in fact, sort of now we're just talking about what are the institutional structures that support or get us to that. So in that sense, then what I would posit is that the story, at least I would put forth, of intersystemic governance of overlapping jurisdiction is a story about structure and process, and not a story about normative content and normative ends. Is that problematic in some respects? Perhaps it is, but that's at least how I would frame it.
So with regard to the universalism point, I agree with what Bob said to the degree that it does, that our accounts, I think, both do focus on structure and process. But I disagree that it can't account for universalism. And I did it a little bit in this short article in the Global Legal Pluralism article that's much longer that I wrote last year. I went into more detail. So one of the things I said is that all decision-making pronouncements are inevitably jurispathik, right? They are going to choose one path over another. What I'm looking for is a kind of self-consciousness about that process and a sympathy or empathy with other possible decision-makers in the process. Now, that doesn't mean that, anything goes. So, for example, I could imagine a decision maker looking at an illiberal, very illiberal say, non-state community in its borders and saying, I'm not going to give full faith and credit type recognition to their decision to lynch someone, right? There's nothing in the idea that pluralism is a useful value that requires you to go that far. All it says is that if you are going to insist on a universal or a trump or a squelching or whatever you want to call it, a jurispacific assertion, you need to justify it. And it may be that certain universals, certain human rights norms or something like that, are in fact justifiable, and that's a political commitment that I or you or any particular community would be making on the world stage, would be arguing for, and would say, you know, in this particular case, this norm is so important that it needs to override these local concerns or these other communities or these other decision makers, etc. And then I'm sure there will be other people who will disagree, right? So then you'll have a discussion about that and you'll have a fight about it. So it's not as if you ever get to a point outside the system where you can say, well, this norm gets to win. Everyone's within systems and they will argue that, you know, this norm should trump here. And someone else will say, no, it shouldn't because of these other reasons. All I'm saying is that the independent value of the sort of structural value of pluralism and keeping play in the joints should be a factor on the table in the decision, not that it should always win or trump every other value that might be in existence as you're trying as a decision maker to reach a decision or as a community you're trying to make an argument. It simply can't be systematized from the outside, but it doesn't prevent you from making the universal argument. You know, you talk about appropriate spaces of contestation, political versus legal. That's certainly true that this model elides that distinction quite a bit because it's, you know, certainly some legal norms have coercive force behind them because there are people who have guns and military at their disposal, and so their norms will tend to have more valence. So I'm not saying all norms are equal. But these all are different places where norms get articulated, and the distinction between political and legal strikes me as not particularly useful, because all of those things can change what sociologists and anthropologists refer to as legal consciousness over time, just the way in which, as people at the State Department or in policy or in op-ed pieces or whatever, they think about what are the issues on the table. Those issues change over time. What they think is a relevant consideration changes over time, and it changes in part because of things like new international norms in the air. That, you know, that policymakers will have to pay attention to it if for no other reason than that people care about it. You know, even the Bush administration, which was as hostile to certain international organizations as any, had to at least pay lip service to the UN in the run-up to the Iraq War because of popular opinion. That wouldn't have existed, you know, 40 years prior or whatever. So those kinds of contestation, whether in the however you define it, become places where norms get articulated that end up mattering. Finally, deprivileging territorial communities. Peter knows I'm quite on board with that. I have written extensively on sort of the globalization of jurisdiction and thinking of jurisdiction in terms of communities that are not necessarily territorially bound and conceptualizing those relationships. Territory obviously matters to some degree, as you say, at least at the very local level. Territory also might matter to the extent that people are committed to it. You know, people are more willing to die for their nation state than they are to die for their bowling league. So there are differences between the two of them as norm-generating communities. But that being said, there's a tremendous essentialization in law, obviously, of the territorial community, and I think it's increasingly difficult to sustain, both because of the permeability of activities across borders and people across borders, and also these kinds of normative ports of entry, so that it's hard to know, just as it's hard to know whether, you know, a Honda is an American car or not. these days, because it could be made in America even though it's a Japanese corporation, or what's a foreign security versus an American security, et cetera. I think also this idea of privileging only certain territorially based communities is likely not going to be sustainable over time.
I guess in the time that I have, I'd like to briefly talk about three interesting points that Peter made, and then one point that Peggy raised. So first, very briefly, Peter asked, I think quite properly, well, what's room is there for universalism in my approach? I think in one sense, my approach is very universalistic because I support the existing international norm of a strong exit right, and I also argue, at least to some extent, for stronger entry rights than exist in current international law, even though both the exit and entry rights do impinge on the desires of quite a few governments, particularly the entry right, but also the exit right as well. So in that sense, I'm very universalistic. On the other hand, precisely because I think exit and entry have tremendous value, it may be desirable in other areas to constrain the intrusion of international law so that there will be more and hopefully better choices available for those migrating. In another article that I co-authored with John McGuinness, no relation to Peggy, in the Stanford Law Review, we talk about some of the reasons why it's desirable to restrict the intervention of international law, at least into the affairs of democratic states, so as to preserve this diversity that can then allow for exit right to work well. But that diversity, I think, its value is greatly increased if we can constrain state sovereignty in another area, namely their ability to restrict migration. So what we don't want is a world where states have, just in effect, monopolies over their own citizens and, crudely speaking, can abuse them as they want. What I would have hoped for is a world where people can choose their states at least to a greater extent than they can today. Now, Peter also says maybe I'm excessively reifying or essentializing the state, and I'm actually kind of happy to get a criticism like that because as a libertarian, I very rarely get criticized for privileging state power too much, right? Like most people say, no, to the contrary, you're a radical, wants to destroy state power and doesn't appreciate its value. I guess in this instance, I would say two things. One is, I think it will turn out that I'm overall more hostile to states than Peter is. I'm not completely sure about that, but reading his work and my work, I think it's hard to avoid that conclusion. Second, and perhaps more to the point, it seems to me that, like it or not, and I don't always like it, variations in government policy do have an enormous impact in people's lives, and in this talk of de-essentialization and pluralism, I think we're perhaps in danger of losing sight of that. There's an enormous literature which shows that in terms of economic outcomes, human rights outcomes, and almost any outcomes that we might care about, there's a tremendous impact of government policies. One need only look at North Korea right next to South Korea, culturally and otherwise very similar, but radical divergences because there are different policies. There's many other similar examples. So freer migration rights can allow people to take advantage of those differences and hopefully, while at the same time perhaps mitigating some of their worst impacts. But I agree, perhaps to a greater extent than Peter does, in the long run what we want to do is reduce the impact of states on people's lives, but that's perhaps for another paper, not for this one. Now, third, Peter says, well, maybe this assumes atomized individuals who are, rational calculators, and I agree, it is a rational choice model, but that doesn't necessarily imply completely atomized individuals. To the contrary, Peter himself mentions people who move as communities, perhaps, for instance, as some Hasidic Jewish groups did when they moved to the United States. And Peter says, well, for these people, their communities matter much more than their state, and that may well be true. I think he's right in some cases. However, ask yourself, why did they move to the U.S. in the first place? If really all that mattered was their community and they didn't care about what state they were living in that much, why did they move? And the answer, of course, that their community could flourish much better, so they thought, under U.S. government policies, under the policies of Poland or Russia or the country that they left. And so I think movement is not just for the atomized individuals, it can also benefit individuals who want communitarian and other advantages, precisely because government policies also influence how well certain kinds of communities can flourish, and those advantages too can be exploited through freedom of migration. Finally, Peggy raises the interesting point about, well, what about economically motivated migration as opposed to politically or human rights motivated? In the last part of my paper, which I didn't talk about that much presentation, I to some extent questioned this distinction because economic conditions in different countries are tremendously influenced by variation in government policy. The North Korea-South Korea example I mentioned is a particularly dramatic instance, but there are many, many other examples I can mention, and there's a huge systematic literature on this, some of which I cite. So people who are who we can think of as economic migrants, in many ways really are political migrants. Now, she says, well, maybe when they migrate for economic reasons, they make themselves worse off in other ways. And that may be true in some instances. However, I think in most cases, the potential migrant and his or her family are the ones who are in the best position to decide whether the trade-off is worth it or not. So, yes, maybe when a Mexican moves to the United States, he takes the risk that if he kills somebody, he might be subject to a death penalty, and that's a negative compared to staying in Mexico. However, I think for many of these Mexicans, they can quite rationally decide that the other advantages of living in the U.S. Vastly outweigh this relatively small risk of being sentenced to death, especially if you can avoid any risk at all if you just forego killing people yourself. So that's not to make light of the death penalty at all. I clerk on the Fifth Circuit. I know that it's a serious issue. And similarly with blacks moving to the North domestically, yes, the North was not a bed of roses, and I certainly don't mean to imply otherwise, but at least it was a much less bad bed of thorns than the South was at the same time. And I think the evidence is overwhelming that even though life was far from peachy for blacks in the North, it was vastly better for them than it was in the South, which is why more than 10% of the black population in the South did in fact move north during the 20 or 30 years at the start of the 20th century. It was not a bed of roses, but it was a lot better than the available alternative. And I think I'll end there and see what questions people have. Hopefully, we haven't delayed too much the exciting voting with your feet that you might do to get the refreshments that I know you're eager for.
Yeah, that's the real voting with the feet.
Yeah.
So, how many questions are there? So to get a sense of. I said Ed has his hand up.
It has been.
This is the real. Yeah. Why don't we do about 5 minutes? Unless people are just dead time. Julian has his hand up too. So Ed and Julian, and then we'll see. Go ahead.
Okay, but I think we're going to do this tomorrow. Well, you tell me.
Let's take 5 minutes.
Okay. So maybe this will be a spur for discussion tomorrow morning. I was sitting here watching self-loathing as a formalist. And then I realized more or less that there are degrees of formalism in all these remarks. For example, I would think, and I think pluralism is the anti-formalist position, but it's not limited strictly to your remarks. I would think we would want, for example, pluralistic rules that would permit, would destroy the ability of a state to pose obstacles to the right of an individual to speak to his or her foreign counsel. So I could imagine easily reaching below the rules, whatever we might think of it, that might be more within a state court, and think what rules do we want in order to really achieve some kind of pluralistic community, some kind of notion, whether it's within a religious community or within a nationalistic community. We would want channels of communication to be reinvigorated, and so we would, for example, just ignore the rules like the state courts have here and override them. And I'm interested in the fact that most of the economists seem to stop at that level and prefer some kind of legal, pre-established regimes rather than disaggregate still further. Second, I don't think, my impression is that pluralism is not sufficiently rigorous or determinative, especially for actors with the one have limited authority. I'm completely unable to determine the distinction between Judge Chappell's concurrence in which he accedes to the ICJ's decision and the President's decision to accede to the ICJ's decision and to impose it only within a limited class, not to generalize it across the state, but only at the litigated class to accept the results of the decision. Similarly, I don't know on the pluralistic view what to make of the ICJ, because one might think on the one hand you want to encourage an ICJ-related discourse. On the other hand, you see the ICJ is becoming increasingly stringent in its orders, establishing its position that provisional measures are binding, and are binding on each and every actor within the domestic system and consistent with international law, regardless of the internal constitutional order, binding immediately upon all of them, totally rejecting the idea that executive clemency is sufficient, requiring that it be mandated through states, oblivious to principles of procedural default, understanding Justice Kennedy, it's very hard for me to understand whether the ICJ is pro or anti-pluralist in this guise. And so, to me, I guess, is a quasi-formalist, well, for these purposes, it's a complete formalist. I don't know what to make of it.
Do you want to respond, Paul?
Yeah. I think I didn't quite understand the very first point, but the Chapel and Bush point and the ICJ point I understood. Could you repeat the first one again?
Let's do it.
Okay.
Yeah.
All right. So, so what would I say? I actually don't want to get too caught up in the specifics of any one decision, because part of the point of a pluralist approach is it's not meant to be a determinative approach that tells you what the answer is in any particular case. In fact, that's part of the whole point, is that it's a framework that gets you out of the mindset of trying to come up with a solution, because in part it recognizes that the solution that anyone comes up with is immediately going to be subverted, challenged, changed, and altered in the way that it gets applied. So it's not really meant to be, and I did the ICJ decision as kind of a thought experiment, but it's not meant to be, here's the way, we should now decide this case. It should come out this way as opposed to that way, and now I've changed your way of resolving the case because I've given you pluralism as a framework. So, so I'm a little hesitant to wade in too much, but I do think the difference between the Chapel and the Bush administration decision is the Bush administration decision is deliberately asserting a executive branch preemption to cut off any further decision-making, discussion, or assertion of norms on the state level. That is different from what Judge Chappelle did, because first of all, he's already on the state level, so he's not squelching anybody else. And secondly, he's responding to the ICJ decision in a way that I think is consonant with this idea, which is that he's treating it as a judgment recognition decision. He treats it within a conflict of laws framework, and he says that this is something that's due a kind of full faith and credit.
That's literally the terms of the President's order, too.
Right, but it's a different level of government, right?
So the question here is simply federal act versus state act, because it's precisely consistent with principles of international comedy. Despite whatever else I think, I'm going to recognize this particular decision and enforce it only to the extent of the decision itself. It seems to me the same thing, unless you say the difference is that he's ordering it as a president as opposed to as a member of the state Supreme Court.
Well, I do think that matters, but I also think there's a difference in the way they analyze it. As to the ICJ, how is that pluralistic? Again, I'm not saying that in my response to Peggy and Peter, I'm not saying that universal norms might not possibly have some valence, and it may be that the ICJ is pushing certain universal norms, and to that degree, someone could disagree with them, or reject them, or whatever, or champion them. All I'm saying is that in that assertion, the ICJ took a number of steps that strike me as less, what would be the squelching is a bad verb, but sort of less cutting off of dialogue than they might have done. Partly because they go through a long justification as opposed to simply just ordering. The Vienna Convention says this, you must do that. There are a lot of international judgments that read like that. Whereas the Vienna Convention exists, you must do that. They didn't do that. They offer a long rhetorical discussion of why, even though there are local policies that go the other way, they're still issuing this judgment. Secondly, they do provide space for, they don't say, as Mexico wanted, first everyone gets out of jail, or something like that, or everyone gets a new trial. They provided, they only really required the barest minimum of a hearing. Yes, clemency wasn't good enough, but pretty much anything else is going to be good enough. Some people are probably are unhappy that they didn't go farther, obviously. But it does seem to me that they bent over backwards to try to give voice to both the universal norm and the local policy, and that's what we would want decision makers to do. How to draw the balance in any particular case, you're going to disagree with me, I'm going to disagree with you, Peggy. Everyone will have a different place to draw the balance. All I'm saying is that the independent value of the sort of intersystemic dialogue should at least be on the table as one of the things you're balancing when you make the decision of whether to push the norm or not push the norm, whether to defer or not defer, whether to recognize the judgment or not recognize the judgment, that should be part of the calculus. But it certainly doesn't give an answer.
But you just add sort of two small pieces to it. So one is that, as I heard you, sort of there was a question of sort of the articulation or the accession by the president and the accession by the judge in Oklahoma. In some sense, my answer to that would be that, again, it's echoing Paul, but stating it slightly differently, is that it's the nature of the decision, not the level. So I don't construe my construction of it as being a notion of finding the Oklahoma judicial decision attractive and the federal level presidential decision unattractive, inherently because of the level of government. In some sense, the very premise is that there is room for the Oklahoma judge to take a position and for the president to take a position. Then it becomes an issue of, again, how the decision is framed. And as Paul gave the example of the ICJ, but it could apply to these others as well. Do they open sort of room for discourse, or do they close the discourse? That seems to me. And you could tell a story that says, at the presidential level, it ends discourse, and at the Oklahoma State Court level, it invites discourse. But you can tell the reverse story as well. But I think that's the. So I don't see any tension in, or at least as I see it, it's not a rejection of the presidential session as opposed to the Oklahoma court session is one. And then the other piece that I put in is that, and this may be an amendment to my initial response, I'd say that it seems to me the claim that I would make is sort of one about comparative institutional analysis. So it's not necessarily, at least not my claim, which may be then more mild than Paul's. It's not my claim that there is in fact that the patterns I describe or I'm interested in are meant to be universally applicable or universally apposite. It may be that comparative institutional analysis suggests to us that in certain circumstances, maybe in certain sort of aspects of international human rights, it is not apposite. And in fact, sort of the appropriate institutional scheme and design is one that is less embracing of pluralism or less embracing of dialogue. But compared to the baseline from which we start, it seems to me that the claim remains the same, that there ought to be a great deal more such overlap in dialogue and engagement than we see now.
I would just have one amendment, which I think is you may be right taking them as they are, but if you take the presidential statement along with the withdrawal from the optional protocol, I think in terms of Judith's point about ongoing dialogues, that shuts it down. There's no more dialogue.
I'm not sure which way that cuts. I agree with you. That's completely. I haven't to find lessons with that. But if we view the ICJ as becoming increasingly, we might romanticize the ICJ by saying it's embracing a pluralism view. We may also say it's understanding the practical limits of its authority, and it's doing so within a political constraint. And so it was finding the balance of those constraints increasingly being loosened, in part because the U.S. is being intransigent.
But that's the point I was making about the European Court of Human Rights, too. A lot of these, what I call sort of hybrid arrangements, complementarity, hybrid courts, they're all born of political compromises, but they tend to be seen as, by partisans on both sides, as less than. And it seems to me those hybrid compromises are sources of creative tension. So even if it is because of the political realities, we could still see that particular way of framing the decision as better along a certain set of axes. Again, it's not the only axis you can look at it, but along a certain set of axes as better than the alternative.
Okay, Julian had his hand up earlier. Asked him to Janet, you're the only thing between us and drinks. You're the only thing between us.
Yeah, Janet's not going to be here tomorrow, so you have to.
I actually want to add one little fact that might sort of underline part of what I said earlier, but I think it's interesting in the dichotomy between Chapel and ICJ. that we all, because Aesop posted Chavel's opinion and was facts around, we all have that opinion and we see his reasoning, but in Oklahoma, that opinion is not published. And it was not published because it was a compromise between the middle of the 5 judges that would not sign on to that ultimate order unless the opinion was not published. So what's interesting here, so what's interesting here is it sort of cuts several ways. One, it may not be sort of the precedential value of it within the court system, within the jurisdiction, is not. I mean, Chavel's opinion means nothing. The political value or discursive value or consciousness value is significant. So I just wanted to raise that because I think it's a nuance that gets overlooked because we just look at this as this is a decision and this is the reasoning, but it's all actually squashed. You could find,
It also goes to the transparency point that came out between Judith and Paul earlier, having to do with all of these various processes and whether transparency is part of the set of concerns.
Doesn't it being on West Holland,
Okay,
transparency?
Pascal.